Control room 1.
Is sir audible?
Am I clearly audible?
Yes, sir. Clearly audible, sir.
Control room, code 1, check 1, 2, 3, 4, 5, 6, audio check, sound check.
Yes, court is ready.
In the heart of India's bustling democracy stands the Supreme Court of India, a beacon of justice and a steadfast guardian of the rule of law. This prestigious institution, with its grand column, filled with the eloquent voices of the nation's leading lawyers, symbolizes more than just a judicial body. It is the embodiment of the hopes and rights of over 1 billion people. As the highest judicial forum and final court of appeal, the Indian Supreme Court holds a pivotal role in upholding the Constitution, protecting human rights, and ensuring that democracy thrives amidst a diverse and complex society. Through its landmark judgments and unwavering commitment to justice, the court not only interprets the law, but also shapes the very fabric of Indian democracy, offering a voice to the voiceless and upholding the ideals of liberty, equality, and fraternity for every citizen. This is the People's Court, whose doors are open to every citizen, whose pronouncements protect the rule of law, and whose verdicts offer a guiding light towards a world where every Indian can live with dignity and free of oppression. This is the Supreme Court of India.
The most important thing about the Supreme Court is that it is a people's court. All the work which we do, whether it's in our judicial function, that is the cases which we decide, or on the administrative side of the Supreme Court, the decisions which we take on both the judicial as well as the administrative sides are geared to making us a people-oriented court.
The 19th century ushered in a pivotal era, marked by the Indian High Courts Act of 1861, paving the way for the common law system in India. The Indian Round Table Conference in 1930 led to the creation of the Federal Court under the Government of India Act 1935, a crucial step in the path towards an all-India judicial tribunal. Echoes of past struggles for judicial independence reverberated through the decades leading to 1950, and with it, the framers of the Constitution aimed for justice, liberty, equality, and fraternity for an emerging nation. Beginning with 8 judges, the court has grown into a towering bastion of justice, standing proudly with the current strength of 34 judges. Over the decades, this esteemed institution would tread a transformative path, giving some path-breaking landmark judgments that not only shaped the legal landscape but also etched a narrative of guarding and passionately protecting the rights of the citizens.
Our objective is to hear the parties and decide as per rule of law and ensure that the guarantees which are given in the Constitution in the form of fundamental rights and other statutory rights made by laws are enforced and implemented.
In its early years of inception, the Supreme Court encountered the challenge of laying down the basic constitutional groundwork for a diverse nation, which sparked new discussions over interpretations of rights and aimed to strike the balance between fundamental freedoms and state power. The 1960s tested the foundational principles of the Constitution's core, and the 1970s evolved as a period of fortifying individual rights. Imagine a constitution, its core protected by an invisible shield. The 1970s saw this shield forged in the fiery courtrooms of cases like Kesavananda Bharati versus State of Kerala, which established the basic structure doctrine, asserting that while the Parliament has the power to amend the Constitution, it cannot alter its basic structure.
The basic structure consists of those values, those principles, which are intrinsic or crucial to our existence as a democratic society governed by the Constitution.
A more expansive interpretation of fundamental rights was done in later cases such as Menka Gandhi versus Union of India, which set a lasting precedent, shaping the trajectory of jurisprudence in India. The ruling expanded the interpretation of Article 21, asserting the right of personal liberty and the meaning of right to life, marking a significant milestone in protecting individual liberties.
So the basic structure in that sense has deeply influenced the way our law has unfolded since the case was decided in 1973, and it continues to have an impact even today.
Dr. Ambedkar was asked a question as to if he's asked which is the most important article in the Constitution without which the Constitution would not be as it is. He answered that, in my opinion, Article 32, which provides a remedy to the citizen to approach the Supreme Court directly, is the heart and soul of the Indian Constitution.
Courtroom battles forged a path for individual liberties, and a more transparent and accessible judiciary, and decisions were taken to advance our social welfare state. From Bennett Coleman and Company versus Union of India to Shreya Singhal versus Union of India, the court shaped the course of free speech, ensuring its protection even in the digital age. The 1980s ushered in a transformative era with the emergence of public interest litigation, PIL.
Public interest litigation has been a very important source of protecting these rights of individuals, rights which any citizen like you or me share in common with others. These rights are shared in common by citizens with other citizens, and therefore the court steps in as a protector of public interest.
The landmark case of Husainara Khatun versus Home Secretary, State of Bihar, ignited the PIL movement.
PIL, if done with the good intention and with the larger public interest in mind, is perhaps one of the most important tools which the Supreme Court and the High Courts have evolved to ensure fundamental rights are given and enforced.
Drawing attention to the plight of under-trial prisoners, the court safeguarded prisoners' rights in Sunil Batra versus Delhi Administration and D.K. Basu versus State of West Bengal, recognizing individual rights by laying down guidelines for arrest and detention. Free legal aid was recognized as a fundamental right under Article 21, ensuring that the state provides legal assistance to the poor and those who could not afford representation. This commitment was reinforced in cases like M.H. Hoskot versus State of Maharashtra and Khatri versus State of Bihar. The judiciary penned the opening chapter of gender equality in Muhammad Ahmad Khan versus Shah Banu Begum case. The court challenged entrenched patriarchal norms, granting maintenance to a divorced Muslim woman beyond the Iddat period. Taking gender equality further, Vishakha versus State of Rajasthan tackled sexual harassment in the workplace, paving the way for a safer environment for women. Dismantling discriminatory practices and promoting inclusivity within the armed forces, women were granted permanent commissions in the Secretary, Ministry of Defence versus Babita Punia, addressing the sexist remarks and stereotypical language used against women. In Aparna Bhatt versus State of Madhya Pradesh, the court realized the immediate necessity for gender sensitization of judicial officers.
Since women are now entering into the highly qualified areas of social growth and social evolution, it's important that their evolution does not stop merely with the acquisition of knowledge in schools and colleges and in super specialities, but that they must have that ability to contribute to the nation.
Protected the reproductive autonomy, dignity and privacy of women in case of X versus Principal Secretary, Health and Family Welfare, Government of NCT Delhi, and held that unmarried women are also entitled to safe abortion.
There have been several
Right to access the internet was recognized as a fundamental right under
of the judgment is normally felt after the judgment is delivered in the form of what impact it has on the society and the public at large.
In the recent years, the Supreme Court of India has resolutely assimilated technology into its core and peripheral function to become accessible, transparent, and efficient.
Our mission is to ensure that technology makes access to justice inclusive and not exclusive.
Supreme Court's hybrid hearing system, an extremely popular initiative boasting of having been used in over 5 lakh hearings, empowers lawyers and litigants with the freedom to choose between the mode of appearance.
We have the state-of-the-art video conferencing facility. We have document readers, we have high-resolution cameras. So, for one of the former Honorable CGI mentioned in the court to an advocate, even if you go to the moon, we can do video conferencing with you.
We have made technology more user-friendly by promoting e-filing of cases. Cases can be e-filed, court fees can be paid online so that people don't have to come to court physically and file their cases.
Futuristic courts embracing state-of-the-art technology equipped with smart LED walls, monitors and document visualizers that redefines courtroom efficiency and transparency. Even in its day-to-day administration, the court has let go of physical files.
My court in the Supreme Court is completely paperless, so all the files which come to me and my colleagues on the bench are digitized, scanned. All the library resources which we require are in the electronic form, and we could be hearing cases online. So the only physical aspect of the hearing is the lawyers who are present in the court and the judges who are present in the court, but otherwise it's completely paperless.
Supreme Court has automated its core workflow with ICMIS, an indigenously developed platform managing cases from filing to disposal. Even SupNet, an internal platform connecting its workforce, ensures instant data sharing among its thousands of employees. Hugely popular online RTI portal has been used by thousands of citizens to file their RTI applications. The Supreme Court of India launched its coveted e-Supreme Court report, popularly known as ESCR platform, in 2023, providing free access to all reported judgments since 1950. Similarly, launch of Digital Supreme Court reports marks a monumental shift in legal information dissemination, promoting accessibility.
Digitization of court records so that our records are available in the digitized form to lawyers. They don't have to seek paper files anymore.
In the Judges Library, we have introduced the RFID technology. We are also developing a digital repository for which we have procured a Bukai 5 publication scanner. So the scanning of the legislation and the important books, rare books, are being done. Now, in 16 regional languages, we are translating the judgments.
The justice is ultimately for a litigant. It's not for a lawyer. In my view, the technology has transformed the working of the working and functioning of the courts in a very large way, beneficial to the citizens of the country.
The e-court projects were conceptualized with the vision to transform Indian judiciary by information and technology enablement of court.
E-Courts is a pan-India project developed under aegis of Supreme Court of India. This pan-India project is implemented in 3,515 district and taluka court complexes across the country. Every single district court complex is now computerized.
We are setting up e-Seva Kendras across India. So throughout every court establishment in India, we are setting up e-Seva Kendras under phase 3 of the e-Courts Mission Mode project. Now this will ensure that all services which are available electronically are provided to citizens even in a physical space, namely the space of the courts, so they can access these services even if they don't have access to the internet or to a smartphone.
Likewise, its online appearance slip portal enables hundreds of lawyers to file their appearance slips in electronic mode. The Virtual Justice Clock portal shares real-time statistics on cases, including cases clearance rate, to keep citizens informed. National Judicial Data Grid, web-based platform, allows citizens to access litigation data across all Indian courts.
So the National Judicial Data Grid in that sense is a comprehensive collection of individual cases going up from the smallest court in India right up to the highest court, namely the Supreme Court in Delhi.
More than 20 crore cases of the district judiciary are available on this forum. Similarly, the judgments of the high courts are available on the National Judicial Data Grid. Now the Supreme Court has also joined National Judicial Data Grid, and the entire data of the Supreme Court is now made available to the public.
The court launched the upgraded blockchain-powered version of its ambitious project, Faster.
We are ensuring that orders which we pass in bail cases are immediately communicated to the jails where convicts or under trials are being housed in custody, so that those orders are implemented effectively. We monitor the implementation of these orders.
The court has enabled on-premise Wi-Fi network access. It has also revamped website with improved user interface and enhanced accessibility features. Live streaming of proceedings has elevated transparency of courtroom proceedings.
So access to justice, we have gone to move away from the colonial thinking that you should approach to the court to get the justice. What we are now trying to do, that justice should reach to the doorsteps of the common man. That is the whole theme of this entire exercise of introduction of technology.
From granite walls to modern technology, the Supreme Court story marches ahead, synchronizing progress and justice. Each turn of the page, a chapter in India's quest for a better tomorrow. Fueled by the relentless human spirit.
If Supreme Court is like a person, I'll say my hands are out to shake hands with you. Come to us and we will, whenever you're in difficulty, whenever you have an issue or a dispute, we'll resolve it. And resolve it in a fair, just manner, ensuring that your fundamental rights are protected.
Over the last 75 years, we as judges have taken a variety of steps to ensure that in the work which we do, in the way in which we interpret constitutional rights and duties, we give effect to the Indian ethos. I think we should be saying to citizens of India as persons that we exist for you. And the reason for our existence is you, our citizens, people whose faith sustains the work which we do.